Okay, welcome. I'm Ed Walters. I'll introduce Damien Riehl and Joshua Lenon, all of us from Clio. In the news this week, we saw a lot of commentary about United States versus Heppner, a case in which Southern District of New York Judge Jed Rakoff held that a client's consultation with an AI chatbot about his case was not privileged under attorney-client privilege or the work product privilege. And a lot of what we've seen about this was a breathless response saying, wait, is work with AI not subject to privilege? Do you waive privilege by using AI? And we've been having a conversation between Joshua and Damien and me, taking a somewhat more nuanced view of the case. And so instead of speculating among ourselves, we thought we would just take a minute to discuss it. And let's do it like a law school classroom. Joshua, tell us the facts of United States versus Heppner.
You got it. So the defendant, Heppner, was actually under grand jury indictment for a whole host of criminal charges: wire fraud, securities fraud, conspiracy to commit securities fraud, and more. The grand jury returned this indictment, at which point Heppner was actually subject to arrest, and there was a warrant issued upon his premises in which the government seized a wide variety of materials, including the 31 documents in question in this order. These documents were flagged by Heppner's counsel as materials that either contained privileged information and so should be excluded as evidence, or were subject to the Work Product Doctrine.
Joshua, let me interrupt you for just 1 second. What are these documents? What's in them?
Well, these documents are actually documents generated by Heppner with the free version of Claude AI. Claude AI is a generative AI tool. It has both free and paid plans that are accessible to people. And it was not a corporate account, a paid account, or the law firm's account with Claude that generated the documents in question, but instead a free account utilized by the defendant Heppner, generating documents about which some of the communications he had with his attorney were included either as part of the prompts or as part of reference material there.
And let me make sure I've got this right. Heppner is indicted, and he goes into the free version of Claude, the train on my questions and answers version of Claude, and says, I need legal strategy. What can I do here? Here are my facts. Give me some defenses. What can I expect? What's going to happen in this case? And then prints out the answers like a paper.
Absolutely.
And has them on a desk. And when the FBI has this warrant to search his house, they seize a bunch of stuff, including the printouts from Claude.
That's right. What was interesting about this is they were flagged as AI documents in the privilege, and as privileged, not just that they were communications, not just that they were notes, but AI generated notes as part of the objection to having them included, right? And so as Rakoff...
Again, I'm sorry to interrupt. Let me make sure I've got this right. So there's an objection.
Yes.
And Heppner's lawyer at this point comes in and says, all right, you've taken all this evidence. I want you to set aside these printouts from Claude, from all the other evidence. We're going to object to this being introduced. I'm objecting, the lawyer says, for what grounds?
Yeah, and the lawyer was objecting to the fact that they either were attorney-client privilege communications or work product. And what is labeled in these documents is that they are prepared reports that outline defense strategy, that outlined what Heppner might argue with respect to the facts in the law that we anticipated the government might be charging. So the counsel is saying this is work product, or like really inside baseball between me and my client, right? And the government held off on reviewing these documents, but eventually came back to the judge and said, no, really, we should not be applying privilege or work product doctrine to any of these documents, and asked for the judge to make a ruling. And that's what we see today. The judge said neither apply.
That's a great setup. Your law school professors, I'm sure, would be very proud with that statement of the case. Excellent statement of the facts, Mr. Lenon. Damien, what does Judge Rakoff hold in this case? First of all, who is Judge Jed Rakoff?
is an esteemed judge that has done some of the most consequential decisions in the 20th and 21st centuries. It's hard to understate how important this judge is and how he's gotten it right so often, so many years. So I would say that he's a very well-respected judge, is maybe my short answer.
Like an oracle, right? What he says before anyone else says is how we end up with the standards for everyone else, like with e-discovery.
I think, he e-discovery. I was just going to say, he did a lot of the seminal e-discovery cases.
And so Judge Rakoff, at this point, is not a young judge, right?
83.
Yeah. And so he's facing these AI issues as a relatively senior judge. Tell me about the holding of the case.
2 issues, of course, attorney-client privilege and work product, and he takes each. With attorney-client privilege, he points to a case saying there are 3 elements. Element number 1, it has to be a communication between a client and his or her attorney. So number 1, communication between client and attorney. Number 2, intended to be, and in fact was, kept confidential. Confidentiality is number 2. Number 3, for the purpose of obtaining or providing legal advice. So 1, client-lawyer communication. 2, confidential, both intended and in fact was. And number 3, obtaining legal advice.
Let's do the holding for this one first, and then we'll go to the work product privilege.
That sounds great. So with that one, he says they lack definitely 2, maybe all 3. He said for number 1, this is not a communication between Heppner and his counsel because Claude isn't an attorney. That seems like a pretty easy one. To Joshua's discussion of the facts, there is some ambiguity in the decision as to whether did Heppner start searching on Claude, then get a lawyer? Or did he get a lawyer and then start searching on Claude? That's option 2. Or did he start searching on Claude, get a lawyer, and then search more on Claude? Those are the 3 options, and it's ambiguous as to which it is. Let's assume that he searched Claude before he got a lawyer, at least some of the searches before he got a lawyer. Of course, that's not an attorney-client discussion. That's just him jamming with Claude. But then the question is, how is that different than any self-represented lawyer or self-represented litigant?
Well, Damien, you're getting ahead of us here. So I want to talk the judge's holding in this case.
Okay, so it's judge's holding. Number 1, not a lawyer. Number 2, it was not confidential. And for that, he really points to, listen, this is a communication that is with Claude, free version, that says, let's train on your data with the free version. This is not confidential. And then number 3 said, this is not for the purpose of obtaining legal advice. Because Claude, as part of their disclaimers, their terms of service, saying, hey, I'm not a lawyer. I can't provide you legal advice. You should consult with a qualified attorney. Therefore, option number 3, that it is not for the purpose of obtaining legal advice. Claude told you so. So that's
Rakoff, kind of vacillates on this point a little bit. He says, look, obviously not a communication with a lawyer, obviously not confidential. For the purposes of obtaining legal advice, I don't really know. But look, let's just say it's not. And so you definitely fail in the first 2. You need all 3. You mostly fail in the third one. No attorney-client privilege.
That's right. Attorney-client privilege because there's no lawyer, essentially, is the big takeaway. But then work product doctrine, that at its core shelters mental processes of the attorney. Again, this is attorney-centric, providing a privileged area that attorney can analyze the client's case. So the question is this material that's created in anticipation of litigation to be able to help the mental process of the attorney or to be able to reflect the mental processes of the attorney? And again, this one he knocks down, saying that the AI documents don't merit protection under work product because even assuming that they were in anticipation of litigation, they were not prepared by or at the behest of counsel. So they didn't reflect defense counsel's strategy. This counters a little bit to what the facts, at least at the hearing, the lawyer said that some of the stuff that the lawyer said made its way into the Claude questions and answers. So there's at least some fact dispute as to whether that's true, whether it reflected the strategy. But the lawyer at the hearing did say, I did not ask the person to go to Claude. I did not ask the defendant to do that. He vacillates a little bit on this work product too, kind of like he vacillated on number 3, saying that, there's a bit of, can apply work product doctrine, but it has to be at the lawyer's behest. Those are the 2 decisions. And I think we can maybe have some good discussion as to whether they're right, wrong, or otherwise.
The counsel for Heppner actually admitted in the hearing, ruling on the work product doctrine, that they did not request these documents be generated in Claude. Well, didn't request these documents be generated, period, much less in Claude. And I think that was the final chink in the armor for the work product ruling, is because they were made without the knowledge of the lawyer. It just could not fall under the lawyer's mental processes.
So let me just put an end cap on this, and then we'll have a little bit of discussion about it. So Judge Rakoff is not holding here that you waive privilege when you use generative AI. And in fact, he's not saying if you use generative AI, you aren't qualified for attorney-client privilege or work product privilege. In this case, it's about a client who is freelancing a little bit, who is without the lawyer, without a request of the lawyer, or not at the lawyer's behest, not in communication with the lawyer, by himself, using generative AI and using the free, public, non-confidential version of AI at that. So let me just twist this a little bit. Let's do some counterfactual hypotheticals. Imagine for a second this client is using the paid version, or they're using a legal AI tool like Clio Work or Vincent AI or CoCounsel or something else that has zero data retention and has like those kinds of protections, a confidential model. Would that change Judge Rakoff's analysis for attorney-client privilege?
So with all the same facts, but only the tool in question being different, I actually don't think it would. And the reason for this is, in the first part, you have to have that communication with your lawyer for attorney-client privilege. And again, we have a client who's going off script, right? They're freelancing. So even though they're using a different tool, I think the privilege argument would still fall. So in that aspect, the paid or not paid doesn't matter. If we go to the work product argument, right? I think you could see facts that support this being work product, even if the client is freelancing on their own. For example, it may be that they're accessing the law firm's paid tool, right? And utilizing tools provided by the law firm as a part of client service. That might be a fact scenario where the work product doctrine stands and these documents are excluded. But if it is not something where it's very clearly part of an interaction with the lawyer, but instead something like he went and paid for his own personal free Claude account, I think you would still see work product arguments fail in this instance, because we have still this divorced process away from the lawyer and their mental processes.
Let's take this. I'm a jailhouse lawyer where I'm self-represented. I use the jail provided iPad to be able to do legal research. Is that work product protected?
There are some cases in the second district where pro se litigants can claim work product protection, and they've been supported in that, right?
So if Heppner, under a scenario, let's assume that he didn't have a lawyer, did some Claude research, then later got a lawyer, and then did the research, wouldn't he be in scenario one, much like the jailhouse lawyer?
I think one question is, do you have slightly less privilege for your own communications with the chatbot if you have a lawyer also? Like if you are doing your own research and have a lawyer, is it less privileged than if you were self-represented and were acting as your own lawyer?
So that's really why I think it's maybe interesting that it's ambiguous as to whether he had the lawyer or not, because he's almost like Schrodinger's cat, where so under the ambiguous facts, we can say he's self-represented in the first part and then has representation on the second part. So I wonder if we could maybe split it to be able to say, hey, he might be like either a jailhouse lawyer or a self-represented litigant under scenario one. And then he would probably have a pretty good work product argument, wouldn't he?
I would argue there's a completely different standard at play here. That's not work product. I would argue Fifth Amendment protection.
This is not self-incrimination, right? I mean, this is like a search pursuant to a warrant. Different facts. You might have Fourth and Fifth Amendment protections if there weren't a warrant in this case, but there was a warrant. And so we're out of like search and seizure world and into privilege world. Again, not to be too much of the law professor about it, but I want to make sure that we're talking about the issues in this case. There was a warrant and the FBI seized printouts, like actual papers from this house pursuant to that warrant. I think the interesting nuance to this is, would someone who is self-represented be able to say, look, just because I don't have a lawyer doesn't mean I can't get some privilege to discuss strategy, to figure out what kinds of things I want to argue in a space that is protected with some sort of privilege? I think Judge Rakoff's opinion was super sound with the following exception. I think it's very clear that on the third prong of attorney-client privilege, that Heppner is definitely trying to get legal advice from Claude. He is definitely doing this for the purpose of obtaining legal advice.
Part of why that's there's no standard of quality for the legal advice in this privileged test, right? It's not you got actually good legal advice. It's just that that's what you're seeking, right? And Claude tells you it is not built to provide legal advice. It's not a lawyer. This is not fit for purpose. And that was kind of considered probative by Rakoff, but it could just be bad legal advice, right? Where do you get it from?
This is maybe the first time in human history where work product and attorney-client privilege might kind of merge, because they used to be different. You would go to, Google Scholar or to a VLEX or to Fastcase before that, and you would do work product-y things, but never do privilege-y things. But now you can actually talk to the AI, which might be a research tool in the case of Vincent and Clio Work. So you can actually communicate, where in the past it was just a query. I think there's a real question as to if someone treats something like a duck and it quacks like a lawyer, is it privileged?
Amy, you actually said, like, how would you make this argument, right? If I were a lawyer representing Heppner and I were trying to argue for some sort of privilege for these printouts from Claude, how would I do it? So tell me about your process.
So I used my handy dandy legal counsel named Vincent. I put in the form an argument. And with Vincent, you could be able to actually say all the facts of the case. You could say a consumer does legal research before consulting a lawyer. As part of that research, they consult with AI to develop their legal strategy. And much like a person who could afford a lawyer would consult with a lawyer, that might be privileged. So some have argued that consulting with AI is not privileged. I'm looking at you, Judge Rakoff. But that argument is wrong, since privilege shouldn't depend on whether someone can afford a lawyer or not, because privilege belongs to the consumer. This is something that Rakoff didn't talk about. It doesn't belong to the lawyer. Privilege belongs to the consumer, and the lawyer can't waive privilege. It's only up to me. So if it belongs to the consumer, I should get that privilege whether I'm talking to a human or whether I'm talking to an AI that I can afford. Otherwise, you're going to say just privilege goes to lawyers. And if you can't afford a lawyer, you don't get privilege. And that's the best justice money can buy. So I primed it with this. And I said, support this argument. Attorney-client privilege belongs to the person seeking advice. So when a non-lawyer consumer does their own legal research, that legal research is not discoverable. It's privileged. And it came up with a bunch of arguments saying that, yes, this is the equivalent of legal research and privileged communications. Yes, this public policy says that we need to help access to justice. If you don't privilege things, then it can't be. And it belongs to the person seeking legal advice. And there's a chilling effect. If people aren't allowed to be able to say everything that is all the facts, we know that that lawyer will do a horrible job. And we know that that self-represented litigant who can't lay all warts and all of their facts to the AI will also get a horrible outcome.
I just want to say, this blows my mind every time. Like, you describe the facts, and then Vincent goes through and says, I'm going to do some issue spotting. And here are 4 arguments that you can make in support of a change in the law based on what the existing law is. And these are pretty nuanced arguments, right? That there's a functional equivalence between research and privileged communications. There's an access to justice argument that you can make. The privilege belongs to the seeker of the advice. Like, these are pretty sophisticated arguments. Like, I think if I were doing an issue spotting exam, these would be like A+ theories for the case.
100%. And then you can download all of it to Word, which I did. The prompt was saying something like, I'm going to be on a podcast. Please make the best arguments here. And the argument number 1 that it said is that, hey, listen, this is a common law system. So we need to change with the times. We didn't have this merger of the Work Product Doctrine and the Attorney-Client Privilege Doctrine until now. So you can make good public policy in the way that you hadn't before.
Joshua, any closing thoughts?
I think this is just the first of many cases we're going to see about this, right? We've been arguing that there are some very specific facts that led to this ruling. And there's also some ambiguity in the facts to which we're aware, and raised some real questions on, can this go a different way? So I think we're going to continue to see these cases appear in courts. We're going to see varied outcomes that we're going to have to tease the nuances out of. Fortunately, that just means, I think, more work for lawyers in the future. I think there's also a second lesson here that's not contained within the text. And that's, what do I do as a lawyer to prevent my clients from making this mistake? And Rakoff doesn't go into that, but I think it's a good idea for us to do that. This is, I think, not a story about generative AI. and privilege. I think this is a story about how do you train your clients not to do dumb things? Oh,
Yeah. So if your client went to the barber shop and asked the barber, like, hey, what do you think about my theory of the case? Tell me some arguments. I'm going to run these by you. And then the government goes to interview the barber. There
yeah,
wouldn't be any privilege in that communication
that's
right?
absolutely the case.
Unless
So
the barber
I-
were also a lawyer. That would be an amazing law firm, by the way.
So let's do a variation on the barber. Let's say that I have a health scare and I'm going to do my WebMD and Google search. ChatGPT has a HIPAA compliant health aspect of ChatGPT. And I go through and ask a whole bunch of questions in preparation for my medical exam. Can the doctor go into that? Because I'm preparing for my medical exam to be able to do this. And do we want as public policy to be able to say, no, medical privilege, which you would have with your doctor, doesn't apply with ChatGPT's thing? So I think we're going to have to deal with this, not just for legal, but also for medical and all the other therapist privilege. There's all sorts of ways that we'll have to think about privilege.
Damien, based on this ruling, it is also crystal clear that a lawyer using generative AI, and especially zero data retention tools like Vincent AI, has work product privilege for all of her work.
That's 100% right, especially when you have confidentiality and security baked in. A SOC 2 Type 2 certification, ISO security certification. If it's secure at rest, and if we don't train on your data, and our partners at OpenAI and Anthropic and others don't train on the data, and if we spend a lot of money to make sure that's so, of course, that is privileged, just like it would be privileged with any other legal research tool.
If Heppner's lawyer said, hey, I am going to suggest a couple of things that I want you to research on your own before we sit down together. And she says, here are a couple of theories. Don't use, one of the free tools. Go find something that is locked down, pay the $20 a month, use the confidentiality protecting version, and go do some research. And then we'll meet again about this in a month. And in the intervening time, there's a search warrant and they pull the printouts. It's pretty clear that is also like attorney-client privilege, yes?
And work product too.
I guess I just want to have a little bit of an antidote to some of the hyperventilating that was happening on especially LinkedIn this week, saying, oh my God, the generative AI waives privilege. Like that is not at all what's being held in this case. This is really more of a case where bad facts make bad law. The client in
clients
this
make
case,
bad decisions.
yeah, so the client in this case, again, doesn't have the benefit of this opinion, doesn't really know that doing this could be discoverable. And now we have this very clear opinion from Judge Rakoff, who once again is the oracle for legal tech and tells us, when clients are doing this by themselves on the kind of free tools, there's no protection for that can be discovered as a part of the trial.
The biggest question is how many people are going to follow in Judge Rakoff's wake, and what kind of chilling effect does this have on pro se plaintiffs? Self-represented litigants, I worry about some damage that this might have. Hey, if you're a jailhouse lawyer or if you are a self-represented litigant, all of your dirty laundry is open for everyone to see because you can't afford a lawyer. That would be a bad result.
We're going to see them carving out exceptions. Now, it's not going to be every pro se litigant in every tool, right? But there is going to be combinations of though, where they're like, clearly, we can extend work product doctrine here.
Yeah, this is maybe the best public ad for the $20 a month confidentiality protecting versions of ChatGPT and Claude. Guys, it's been fun having this conversation with you. As these new developments come up, we might assemble again and brainstorm about them a little bit. But I think our takeaway here is that the legal AI tools certainly are privileged in the ways that we have always expected they would be. This is really a holding about clients and maybe a cautionary tale for clients and how they use the public tools. I'm Ed Walters for Damien Riehl and Joshua Lenon. Thanks for listening.